Good afternoon, ladies and gentlemen. We're starting the third part of the conference. As Juoza said, it will be the most fruitful content-wise, as we're going to have very many speakers, and the speakers represent 3 different countries. I'm going to moderate the part together with Dr. Vytautas Mizaras, Justice of the Constitutional Court of the Republic of Lithuania. I myself am Jolita Miliuvienė, lecturer of Mykolas Romeris University. Well, since Dr. Miliuvienė has already introduced me, I will continue with the moderation of the third part of this conference. In my turn, I'd like to congratulate everyone and welcome everyone to the conference. And I would like to congratulate you on the occasion of the 30th anniversary of the Constitution of Lithuania. It is very nice to moderate this part of the conference because, as it has been said, it will be very rich content-wise. Other parts also were very rich, but when it comes to topics and number of keynote speakers, there are many. My colleague and I have already looked into the content of the presentations. Therefore, we can very responsibly say that the issues that will be raised during those presentations will be extraordinary and rather complex. They will give food for thought as to how the problems could be solved. During this part of the conference, we're going to have 5 presentations. Despite the fact that we are very strict moderators and we're going to control the time taken by the keynote speaker. But since these presentations are truly very interesting and the speakers are very interesting themselves, and taking into consideration the fact that formally we are not restricted by the last part of the discussion when it comes to conclusions and closing, so we can tell to the keynote speakers that we will not be very angry if you speak longer than allocated for your presentation. The first presentation will be made by Ms. Sigita Rudėnaitė, chairperson of the Judicial Council and acting president of the Supreme Court of Lithuania. She's going to speak about the official constitutional doctrine as the guarantor of the independence of courts. Well, in fact, it seems that the independence of courts and courts themselves are heard and visible both in the media nowadays as well as in various other formats. So, what happened in Lithuania in this field? That when celebrating the 30th anniversary of the Constitution, we, more often than not, speak about independence of courts. Maybe we see some threats that might arise or that arise for this guarantor and for this power. So we're looking forward to your presentation, Ms. Rudėnaitė. Thank you, Mr. Mizaras. I always try to listen to the words and I will follow the time limit, so just to know, participants of the conference, dear guests, ladies and gentlemen, it was very interesting for me from the very beginning to the people who have drafted the Constitution, who stood at the sources of the Constitution from its early days. Today, I represent the judiciary, and my presentation will be a very realistic, very down-to-earth, rather than theoretical one. Maybe I will use the metaphor by Janina Mirteikienė that Constitution is a wonderful dream. So it's a wonderful dream. It's not a fairy tale. So let me start by saying that the adoption of the Constitution, the date that we are commemorating, is not just a certain point in time. I would say that this was the light of the torch. So from that point, the light goes further and even broader. And the orientation of this light are the values that everyone here, well, the people of Lithuania declared. The people of Lithuania declared that they will pursue democratic, free and independent society and the rule of law. So every one of us, not only those who are representatives of government, but also representatives of civic society, are concerned about the situation in Lithuania. So we should treat Constitution as the exercise book, as a prayer book that we consult from time to time. As the Member of Parliament, Vytenis Andriukaitis, said that we should look through the Constitution from time to time and to see whether we do fulfill the duty, because we are in this ray of torch. Maybe we have moved away from our direction and we stand in the shadow. It seems that after the 30 years of the existence of the Constitution, it is rather banal to repeat the doctrine, what the independence of court means. But I am made to do this by life. When I hear from rather high public officials that courts are part of the structure of public administration. Sometimes they ask in what we differ from other structures. And, well, this seems rather sad, but this encouraged me to remember all the values that have been enshrined in the official constitutional doctrine. So I'll start from the statement that over the 30 years, the doctrine of the independence of the judiciary as one of the fundamental principles of the rule of law has been consistently developed in the constitutional court's rulings and judgments. First and foremost, courts is the judiciary power as one of the three powers of the powers of the state, which is equal to other powers. It may be different in its social role, but it is equal as other powers, the executive and the parliament and the government. We also have established the status of the justice of courts. Today I often receive questions why courts are important. We are important because we fulfill a very exceptional function of justice. The system of independence of courts is rather comprehensive. I'll try to mention some essential features. The inviolability of the judges, the social material guarantees of judges, self-governance of the judiciary, funding of courts, technical maintenance of courts. The constitutional doctrine states that it is universally acknowledged that once one of the guarantors of the independence of courts are violated, we will harm the justice and we will harm the principle of the rule of law. The independence of courts and judges is one of the essential principles of democratic state. In such a state, the independence of the judiciary and the courts is one of the fundamental principles of the democratic rule of law. In such a state, the social role of the judiciary is such that in the administration of justice, the judiciary is obliged to ensure the implementation of the law as expressed in the Constitution, laws and other legal acts, to guarantee the rule of law and to protect human rights and freedoms. The independence of the judge and the judiciary is not a matter in itself, but is a prerequisite to the protection of human rights and freedoms. Therefore, the most important criterion for assessing the independence of the judge and courts is that independence is not a privilege, but one of the most important duties of the judge and courts, deriving from the human right to have an impartial arbiter of disputes guaranteed by the Constitution. Well, it seems that nothing could be added, nothing else could be added in order to ensure that we have a perfect life. So I have quoted you the ruling of the Constitutional Court of the 21st of December of 1999. So anyone is forbidden to interfere with the work of a judge and courts. On the other hand, a judge cannot be independent if the judicial system is not independent. So the Constitutional Court establishes the independence of the court's system as such. The question that I pose is rather rhetoric. Are the postulates of the official constitutional doctrine per se sufficient to ensure real judicial independence in the country? So that is the question that I put forward today, and I will answer again. I will say again that it is a rhetorical question. The Constitution is not a science fiction. Constitution is alive only when it is implemented in life. So it is not enough to have the things written down on the paper. If that was the case, our neighboring countries such as Russia, Belarus, and maybe North Korea would be countries with the rule of law. This is the picture from real life. Is the official constitutional doctrine looks like a horse? Can it ensure real independence of courts? I'm happy about the constitutional doctrine, but I guess Ms. Birmontene has mentioned that it's not the Constitution that has to go and help us in life, but rather us that we have to follow the Constitution. Most probably, almost everyone present here should have the duty and the opportunity to act in this way. As I have mentioned, the Constitution is not a science fiction. Its beauty lies in only when we implement the Constitution in our lives. So I will try to argue, I will try to illustrate my statements in when it comes to the guarantees of the independence of courts, funding of the judiciary and legal regulation of remuneration of judges to ensure the independence of the judiciary. So it's not only about governing the remuneration system. Also, some aspects of the enforcement and implementation of constitutional doctrine. I could not come up with the proper word, so we have to answer how to make sure that the constitutional doctrines are ensured. In order to ensure the independence of courts, and in this particular aspect that I am referring to, it is very important to separate the powers of the executive from the other powers. It is the powers of the executive may be limited to those designed to enable the courts to function. It is the state's duty to provide the courts with adequate working conditions. The substantive basis for the organizational autonomy of the courts is their financial independence from executive decisions. Guaranteeing the organizational independence of the judiciary is one of the fundamental prerequisites for guaranteeing human rights. These are only a few postulates in the constitutional doctrine that have been established by the Constitutional Court back in 1990, and these have to be reminded even today. This is the illustration. The figures that you see here do not refer are only for illustrative purposes. But here you see the figures, the funding that the courts asked for and the funding that it has received. So you see the differences. So we asked for 11 million, only 7 million were allocated. I know it's not as the place for me to come and to ask for funding for courts, and to repeat that courts lack funding. I'd like to demonstrate that, to my opinion, such mechanism in our state that has preserved for very many years is far from being able to ensure independence of courts. On the contrary, if we looked deeper at the situation, if we looked at what corruption is, if we read further in the sources, in the national and international sources, it would become clear that corruption is any illegal interference in the activities of courts. So through funding mechanisms that is purely in the hands of the executive power, the courts can become corrupt and dependent. This is the truth which not everyone wants to hear. In democracies, it is acknowledged that a judge charged with the duty of dealing with conflicts arising in society, including conflicts between a person and the state, must not only be of high professional standing and impeccable reputation, but also be financially independent and secure in his or her future. The state has a duty to set the remuneration of a judge in a manner that is appropriate to the status of the judiciary and the judge, and to the functions and responsibilities exercised. The protection of a judge's remuneration is one of the guarantees of judicial independence. This is again another picture for illustrative purposes, and currently the Parliament is debating the reform of the state, of the public sector, and the reform of the salaries of judges. This data is publicly available. So here you see the funding that is lacking is minus 3.3. So this is not me that has to be speaking about the problem, but rather the politicians. So it is obvious that the constitutional doctrine and the postulate that I have just referred to are not in line with the reality that we have from 2008. Again, we should remind that in order to ensure independence of courts is not the duty of other powers. It is the duty of courts and judges themselves and self-governance of courts to ensure independence of courts. As I am member of the Judicial Council, I know that if courts are not able to ensure independence of courts, if the judges cannot deal with a case when looking into the facts of the case and to be afraid of various influences or to succumb to various temptations. The reform that the deliberation of which is underway is supported by judges and courts. I have been in the field for quite many years, and I can't say that I have received many good news from the authorities when it comes to the mechanism of remuneration of judges. I see that, well, we don't have many people here from the executive branch. I see Andrius Kabišaitis. Maybe we have to make changes. What the Judicial Council is proposing is one of the measures that would help to implement the constitutional doctrine in the life of our state. In our strategic directions for the Lithuanian judiciary that are planned for 10 years to come, so we offer to strengthen the independence and authority of judiciary. We believe that there is a need for a national agreement on the judiciary which would agree on the obligations of the judiciary and political authorities, political parties in the administration of justice, as well as the creation of a rational model for the judiciary. I'd like to emphasize that we are starting with the obligations of the judiciary. We want to start from the criteria that our courts have to comply with. We will commit to comply with the standards if other powers provides the necessary conditions for that. So this is our proposal. We have made this proposal public already. There is yet another idea proposed by the Judicial Council. We do have very many guardians of law. So maybe if there is something unconstitutional in the state going on, maybe a constitutional justice case could be initiated. In many cases, it does happen, but as I have illustrated very clearly, we do have many prevailing problems, and they have prevailed in the judiciary for 30 years. According to Article 106 of the Constitution, the following may appeal to the Constitutional Court on the constitutionality of legal acts: the government, at least on 1/5 of the total number of members of the Seimas, the President of the Republic, as well as the courts, when examining an individual case. And in comparison, I have included the article from the Latvian Constitution. It has been mentioned. The Latvian Constitution is celebrating its centenary, and it does not deal with every single case, but Article 17 of the law on the Constitutional Court of Latvia stipulates that the Judicial Council may apply to the Constitutional Court on the constitutionality of legislation on matters falling within the competence of the Judicial Council. So this example, and this is not, Latvia is not the only state in where judicial self-government uses similar opportunities to apply to the Constitutional Court as other powers. I think that this is in line with the equality of all powers in the state. In its strategic directions, the Judicial Council set an objective to strengthen the self-governance of the judiciary and to establish the right of the Judicial Council to apply to the Constitutional Court. Mr. Šedbaras has once said that he has already prepared some material on addressing to the Constitutional Court with regard to the formation of the Supreme Court of Lithuania. This might be one of the tools to avoid the situations that after 30 years I stand in front of the audience and read the truths that are obvious to everyone, but it is very sad that I believe that there are grounds to have doubts that the system for the remuneration of the judiciary, as well as the funding for the funding of courts, potentially conflicts the Constitution of the Republic of Lithuania. So the Constitutional Court of Latvia has already said that the salaries of courts in comparison to salaries of other branches are against the Constitution. To conclude, I'd like to say that the official constitutional doctrine establishes a sufficient system for guaranteeing the independence of courts. The system is sufficient to empower the courts to properly implement their social role, that is, to administer justice and protect human rights. But as I have said, the existing regulation, the existing legal regulation, and the case law potentially is not in line with the constitutional doctrine and is not in line with the provisions of the Constitution. Therefore, there is a need for some additional instruments to empower the constitutional doctrine to implement in our life. I had some proposals as well, but I hope the 30th anniversary of the Constitution is really a beautiful celebration, but I hope this will not become wreath laying on the monument of Constitution. The celebration should be an incentive for us all to act for the benefit of the Constitution in order to ensure that the dream that we have talked about comes closer to us for the benefit of ourselves, for the benefit of our children, and for the benefit of democratic state and the rule of law. Thank you.
Thank you, Madam Chairperson. The independence of courts and the guarantees for that and the repetition of the arguments is never sufficient. We will continue to do that until the judges feel independent and can concentrate into their constitutional function of implementing justice. The independence of judiciary doctrine is one of the most developed in the constitutional history. And if this doctrine is not fulfilled, nothing can change in Lithuania. So all the government institutions in Lithuania have to be interested in that. Without independent judiciary, we cannot be a democratic state. Now I would like to give the floor to Professor Dr. Skirgailė Žalimienė, President of the Supreme Administrative Court of Lithuania. And she will speak about the challenges of administrative justice in the application of the national and EU law. All the countries and all the institutions are confronted with the challenges of applying administrative justice in line with the EU law. Good afternoon. It is my pleasure to speak on this important occasion. The main challenges for the court as an entity applying positive law is to avoid a formal interpretation and application of the letter of law. I heard the previous speaker. I will try not to repeat those things that have already been mentioned, by the previous speakers. Administrative courts, when analyzing the disputes, focus on the synthesis between the national and EU law and the general value context of these systems and the complementarity of each other, because the EU law as well as the Constitution of the Republic of Lithuania are based on democracy, respect to human rights principles. As I have mentioned, I will not repeat the constitutional doctrine related to the relation between the Constitution and the EU law. Administrative courts unavoidably have the responsibility to consider cases that are related to the EU law. The EU law is considered a part of the Lithuanian legislative framework. The EU provisions have to be applied directly. This coordinated approach is essential in terms of Article 30 and Article 47 of the Charter of Fundamental Rights on the right to legal remedy. I would like to focus the Court of Justice of the EU related to Article 19 of the Treaty of the European Union. It says effective judicial remedy. The Court of Justice of the European Union says that national courts must ensure legal protection affordable to individuals by the provisions of the EU law and the full effectiveness of those provisions. And this is in line with the rule of law principles. Otherwise, the main structural principles of the EU can be violated, or the rule of law. On the other hand, judges commit to implementing the Constitution. And the question arises whether we can have the conflict between those two systems, the constitutional system and the EU law. Today, I will try to reveal by giving examples how these two systems are being combined and whether we face certain problems. But first of all, I would like to say that administrative courts have become strong now and can be called courts that are responsible for informal justice. We apply the EU law, and this is the application of regulations that are directly applicable. For example, general data protection regulation in kindergartens. And the case Klaipėda atvirai and anti-dumping cases. I would name many regulations that we are directly applying in our cases. In the practice of administrative courts, we also base ourselves on directives. Directives are not directly applicable, but the national law should be interpreted together with the directive and to agree on the possible application of the directive directly if it is possible according to the given directive. For example, for professional qualification, international security guarantees, and the directive on the possibility to access information about the environment, etc. National courts, administrative courts, have to ensure judicial remedy and guarantee the effectiveness of the provisions of the EU law. On the other hand, we see that there are certain areas that allow the protection of certain issues to the national level. For example, national identity issues. Previous speakers spoke about it. National identity. This concept can be found in the Constitution of the Republic of Lithuania, and the national judge has to be very careful and see whether the case has a very important aspect, which is national identity. In this case, Constitutional Court should be referred to answer those questions. On the other hand, according to the practice of the Court of Justice of the EU Court, certain courts refer to the EU courts for consideration. For example, a case of 2013 of Italy, where the bar practice possibilities were being considered after the qualification examination. The issue of national identity of Italy was rejected by the court. Another example is the case common of 2016, which considered the issue of the rejection of the same-sex marriage in Lithuania. One more aspect that I would like to note. Certainly, we are responsible in terms of ensuring those two systems. But from the Court of Justice of the EU, we can see that risk case of this year, that in certain cases the supremacy principle of the EU, I mean the supremacy of the EU law, cannot be confronted or conflicted with constitutional principles. For example, in Kryžanos case, the court said that the national court should not apply and should not implement the judgment of the Constitutional Court that is in conflict with the EU law. This theoretical and also practical problem can exist, and this is the problem of the combination of these two systems. Speaking about the application of the EU law in the Lithuanian judiciary, I would like to give one example that is very interesting. and is not very much related to the EU law. This is a law on referendum. In the administrative case, we were considering the decision of the Central Electoral Commission that refused to register the initiative group of citizens for referendum. The Lithuanian Supreme Administrative Court referred to the Constitutional Court for explanation and interpretation and posed a question whether the initiation of amendments to the constitution that are not in line with the Lithuania's international commitments can exist. And the Constitutional Court said that this can be done inasmuch it does not conflict the Constitution, but also stress the necessity of pacta sunt servanda principle. The Lithuanian Supreme Administrative Court emphasized that the adoption of the draft amendment to the Constitution proposed by referendum applicants would lead to a situation whereby the Republic of Lithuania unilaterally, despite the principle of international law, would deny and renounce its obligation to finally adopt the euro currency and entrust the right to issue money to the European Central Bank. The draft proposed by the applicants was not compatible with the constitutional or EU membership obligations of the Republic of Lithuania. The adoption of this draft would lead to disregarding the international obligations of the Republic of Lithuania and at the same time the principle of constitutional pacta sunt servanda. The court also stated that the Constitution requires that unilateral commitments should not be changed. What are the challenges for the Supreme Administrative Court in applying national constitutional provisions and the EU law provisions? The examples in the fundamental rights is most illustrative. Different level rights that are enshrined both in the EU Charter and in the Human Rights Convention and in the constitutions. And the fundamental rights that are considered the main principles of the EU. So the question is, can court, based on the principle of respect for fundamental rights in individual cases, from the Meloni ruling, we can see that the court does not have this right to apply the human rights protection system that is more favorable to the person, or which is rather than that which is discussed in the secondary legislation of the EU. The national court has to look for a proper balance between the national law and the EU legislative principles, and this way of finding the balance is not easy. The fundamental rights in the EU came from certain legislative traditions, and later on the EU level, it's changed. Now it seems that it is time when the fundamental rights of the EU have great influence on the provisions of the constitutions of member states. The European Court proposes several methods that can be used by judges in applying EU law, and one of them is the interpretation according to the fundamental rights. Article 53 of the Charter of the Fundamental Rights stipulates the necessary protection level in line with the Convention and international law. On the other hand, we have to consider Part 4 of Article 52 of the Charter of the Fundamental Rights, where we can see that this combination requires certain detailed interpretation and a more detailed approach. Not all the national aspects are attributable to the EU, and the practice of the courts in member states is uneven. I will not mention those member states and the rulings, court rulings in different areas, but here we should stress that the jurisprudence is different. Though these differences can exist and they are permitted. Now let me move to the practice of the Supreme Administrative Court and harmonization of those systems. One of the best examples concerning inviolability of personal life is the use of name and surname. In this case, this is a part of the right to the private life. It has been analyzed by the court in line with the requirements of the Constitution, the provisions and the interpretations and rulings of the European Court of Justice. Social context has also been taken into consideration. For example, when a child has several citizenship or certain inconveniences of different spelling of the names of a family. So the court rules that this is not clearly regulated by law. And this is not in line with the limitation only by law, because the Constitution allows the spelling of the names in the passport both in Lithuanian and non-Lithuanian alphabet. On the 1st of May, the law on spelling the names and surnames in documents entered into force. Another example of best practice of value-based harmony and complementarity between the Constitution and the provisions of the EU law is related to ensuring the right to inviolability of private life in the interpretation of the concept of family. By withdrawing an institution's refusal to grant a residence permit in the Republic of Lithuania to a third country national in the exercise of his right to family reunification with a national of the EU member state in the event of the same-sex marriage, the Lithuanian Supreme Administrative Court followed the interpretation given by the Constitutional Court in the case under consideration that under the EU law, a member state cannot rely to a public policy clause inter alia that its law does not provide for the same-sex marriage in order to prevent the reunification of an EU citizen who has exercised his or her freedom of movement and that of a third country national of the same sex who has legally married in another member state. The rights of the child and their protection are closely linked to the right to the inviolability of private and family life. As regards various aspects of the implementation of the rights of the child, administrative jurisprudence consistently emphasizes that not only the Constitution but also all the fundamental international legal instruments guaranteeing the protection of human rights, including the Charter, establish the consensus of the state for all decisions concerning children as the overriding criterion. The Constitutional Court was referred in a court and it gave the assessment that the requirement of the residence in the country is not in line with the constitutional principles. We also have a wide area of examples of the right to effective judicial remedy. In Pechtev case, our court referred to the Court of Justice of the European Union. And ask whether the unfreezing of the assets of a person sanctioned by the EU countries can do this, because the regulation does not specify on this. In this case, the Court of Justice of the EU ruled that the situation is impossible where a person cannot use the assets for defense, for effective judicial remedy. So this is one more example when the prejudicial that the Supreme Administrative Court applies the Charter of Fundamental Rights directly and defends the rights of a person. The main challenge of the court as an entity applying positive law is to avoid a formal interpretation and application of the letter of the law. And this is one of the answers in addressing the dilemma between two systems. It is important to take into consideration not only legal regulation, but also the legal content of the violated rights, other goods and principles, so that the judge can see the whole system where the dispute arises. Administrative courts undertake the responsibility to resolve the conflict or resolve the dispute according to the legal regulation objectives. Taking into account the development and evolution of social relations, respect for new aspects related to such relations when assessing the relationship with the provisions of the law applicable to them is the task of justice, which, as the Constitutional Court emphasizes, is an official constitutional doctrine, is established, protected, and defended by the Constitution.
Šią išvadą nacionaliniai teisė puikiai būtent iliustruoja individualaus konstitucinio skundo instituto reikšmė administracijai.
The importance of individual request is a good example.
Lietuvos vyriausio administracinio teismo pozicija yra tokia.
The position of our court is that the court should ensure, after the ruling of the Constitutional Court, an effective, real, and comprehensive removal of anti-constitutional consequences and absolute rectification. What are the conclusions? Administrative jurisprudence essentially follows the direction of non-conflict between the Constitution and the Charter, with its resulting provisions of EU law, emphasizes not only the importance of the international commitments entered into and their compliance, but also the fact that the incompatibility of EU law with the Constitution of the Republic of Lithuania cannot be raised artificially. On the other hand, the courts have to consider cases carefully and to bear in mind that national identities and peculiarities might exist that are enshrined in the Constitution, and they can be a certain exception from the principle of the supremacy of the EU law. The direct applicability of international obligations based on the principles of democracy and respect for fundamental human rights in individual cases may not be restricted under the pretext of the separation of powers and the existence of certain political and economic aspects. EU law and the Constitution of the Republic of Lithuania, as a complementary law based on the same values, guarantee a higher standard of protection and effective implementation of fundamental human rights, which, among other things, obliges the court hearing the case to assess in an informal and systematic manner not only the content, objectives, and results of the EU legal regulation relevant to the case, as well as the broader social context related to this regulation. Thank you.
Thank you very much to the President of the Supreme Administrative Court of Lithuania, Madam Žalimienė, for such an extensive presentation, especially as it is related to the implementation of the rulings of the Constitutional Court in different cases in ensuring the elimination of violation of rights and other infringements. The membership in the European Union and the membership in the Council also requires the proper implementation of the obligations. Now, allow me to express one idea. You have touched upon it, but I would like to explore it a little bit more on what kind of human rights protection could be applicable in case of different systems.
For me, the position of the German Federal Court is very important because it says we have been applying and we would apply the standards that ensures the highest protection of human rights. I think that this position would be very suitable for Lithuania as well. We have to ensure the highest level protection of human rights. And we would have to consider it part of our constitutional identity. Therefore, I think the example of the German Federal Court and its position is very interesting and suitable to follow. And one other thing, you have talked about statistical data. And I would like to commend the courts of the administrative justice because there were 61 applications. 61 times the Constitutional Court has been referred to in administrative cases regarding the compliance of legal acts with the Constitution and constitutional principles. Therefore, other courts are very active in raising these issues. Your court is also very active as far as referrals to the Court of Justice of the European Union. And this demonstrates that your presentation is very topical. And these numbers, they just confirm what you have talked about. We will have time for questions in our discussion part. And now I would like to give the floor to Mr. Mindaugas Kukaitis, Chairman of the Council of the Lithuanian Bar Association. And the topic of his presentation is the right to judicial protection and problems in the exercise of this right. Because it's very important because it is one of the main provision of our legal system. Good afternoon, colleagues. I congratulate you all on the Constitution Day and on the possibility to base the rights and freedoms on the Constitution of Lithuania and the values enshrined in it in an independent country for 30 years already. Thank you to those who created the Constitution and to the signatory for us, for not only establishing the Constitution, but also for the ability to defend our rights based on it. I had a question when, as an attorney, I need to use the Constitution in my professional activities. And the answer is the following. I need it not when I talk about the history of Constitution, but when I have in mind a much greater, more substantial or more intolerable restriction of human rights, a violation that we want to eliminate as soon as possible and make sure that such a violation is not repeated. The Constitution is like a shield that protects human rights and freedoms, and if the shield is not used for its intended purpose, it is not do its work, then a person feels extremely vulnerable, distrustful of the law, of justice, of the state. At the same time, it is a sword that allows us to fight for human rights on the basis of the highest law when all the other means have been exhausted. So let us defend and protect what is the guarantor of the stability of our state, and I have in mind the Constitution and its values. Last year, at this excellent conference, I spoke about the right to defense as a safeguard of the principle of the rule of law, and I discussed in detail the frequent violations of for the lawyers when they work with clients, the different restrictions on illegal surveillance, on breaching their secrets, and about the desire to start investigations loudly and to make the names, positions, and images of persons under suspicion public, and to speak about it as if the crime has already been investigated. Article 31 of the Constitution guarantees one of the most important things, the presumption of innocence. The restriction of the right to defense of low-income persons by the public authorities by providing a lawyer for the socially vulnerable group. Each year, there are about 20,000 cases like that. However, the attorneys are paid only a fifth of the market price, which is 20 euros per hour. All of these violations of constitutional values are still relevant today. The right to judicial remedy is inseparable from everyone's right to defense. And the role of the lawyer is to assist the person to exercise this right. I shall go on and raise other examples of how the right to defense is restricted. And today, I am going to use the idea expressed in the conference about a dream. And it is important not to talk about the dream. And when we speak about the dream, then it is no longer a dream, it's a goal. Therefore, having this in mind, I move on to something very basic, the confidentiality between the lawyer and the client as an essential rule to defense. The right to have a lawyer and the right to defense are absolute. They cannot be denied or restricted on any grounds and under any conditions. The European Court of Human Rights, in its interpretation of law, has stated that if a lawyer were not unable to discuss with his or her client and to obtain confidential instructions without the intervention of third parties, the assistance of a lawyer would lose much of its usefulness, because the Convention guarantees the effective defense of the rights. Moreover, the same court said that interference in the communication between a lawyer and his or her client undoubtedly undermines the protection of professional secrecy, which is at the heart of the relationship and of trust between a lawyer and his or her client. In other words, the right to a fair trial or legal defense is unthinkable without the right to communicate directly with one's lawyer. The lawyer-client relationship is in principle a confidential one, and this relationship has to be, one has to ensure that nobody is listening into the conversation, and this is part of the public interest. Meanwhile, the Lithuanian Bar Association periodically receives reports from lawyers about attempts by the pre-trial investigators to question a lawyer as a witness about the circumstances which he or she has learned in the course of his or her professional duties. We are no longer surprised by this. However, the dream is coming true in a way, because we have been waiting, and now we are very happy that the Supreme Court of Lithuania has finally examined a criminal case and adopted a verdict on the 16th of March 2022 and stated the essential violation of the right to defense, because it has been determined that pre-trial investigation officers not only questioned the lawyer about the circumstances which she had learned while representing her client in another case, but they also carried out secret surveillance of the lawyer and her client and recorded their conversations. Moreover, following the reorganization of prisons and penitentiary institutions, lawyers are allowed to meet with their clients only in a general room with the presence of the officer, or in an individual room when the conversation is video recorded. And this is not secret. This is the official answer. And it says that this is for our security, but nobody knows whether the client is protected or we are protected. In the penitentiary institutions, attorneys and their clients have a right to have confidential communication. However, these restrictions are not in line with the first part of Article 30 of the Constitution, and they are not in line with the European Union and other international pieces of legislation. The pre-trial investigation officers started to search the lawyer's home without even raising suspicions against the lawyer. And the computer was seized, and the analysis of the computer's data was carried out in the absence of the Bar Association's representative, even despite the fact that Article 46, it's Part 4 of the law of the Bar Association, forbids such a procedure. And only Turkey, Belarus, and Russia have worse conditions than Lithuania. We have been saying for a long time that in Lithuania it is very common to detain a person for up to 48 hours, and the pre-trial detentions limit human rights before the court. And the liberty, when the liberty is being restricted. And it is customary in Lithuania to deprive of the freedom temporarily of thousands of people in Lithuania. However, this year there are fewer persons detained, especially when the person is considered to be drunk, and now there are few of these persons detained. There was a change in the human rights protection due to our efforts, discussions, compromises. The Article 140 of the Code of the Penal Process was amended, which imposed an obligation on the prosecutor or pre-trial investigation officer to justify why it was necessary to immediately restrain the person's liberty, and why this person was not taken to court that would take the decision. Because normally they say that the person may hide or may interfere with investigation. Now the person may appeal against such a ruling of the prosecutor. We're doing our best, and we are trying to change this practice when the persons are very readily detained. The Article 44 of the law on the bar establishes the right of an attorney to obtain the information from the state and municipal institutions as well as registers for using this information for legal protection. However, we have been witnessing that it has been the attorney's possibility to obtain this information has been restricted, and especially there were plans to punish the attorney if he or she is not going to use the information obtained. And it is great that this year, this month, the Supreme Court of Lithuania, the Administrative Court of Lithuania, has stated the attorney's right to receive the data from the register and indicated that this is the right and the choice of an attorney. Another excellent example is the implementation of the court ruling of the Constitutional Court. The Constitutional Court stated that Article 106 of the Code of the Criminal Procedure, when the person was not reimbursed on expenses. As of the 1st of May, Part 3 of Article 106 of the Criminal Procedures entered into force. And this is the first step when implementing the decision of the Constitutional Court. Now, the person will be able to defend his or her rights with the help of the lawyer, and having the expenses reimbursed. This is an excellent example how the Ministry of Justice and the Seimas heard the rulings of the court. However, this is only the first step. We incur these expenses only when we manage this difficult road and when the person is deemed innocent. We have few hopes that this will be amended when the new budget is adopted. We also hope for the proper reimbursement for the lawyers, because this improper reimbursement is also a violation of the law. And hopefully we will receive the appropriate remuneration when defending socially disadvantaged people. The Constitution has the guidelines for the entire legal system. Therefore, it is very important to follow the rules. It is part of the rule of law. Thank you for this possibility to be critical towards the Constitution. On the 30th anniversary of the Constitution, on behalf of the Lithuanian Bar Association, I wish all of us the ability to nurture the provisions and to defend the rights of people and lawyers. Be safe and defend your rights.
Thank you, Mr. Kukaitis, for emphasizing and reminding us the important principle of our Constitution. This shows that our Constitution is so universal The right to remedy and the right to effective remedy has become very important when the constitutional claim was made. Because the Constitutional Court is being referred to when there is a conflict between the law and the Constitution. We are having the first fruits that we can reap. One of the cases has been mentioned by Mr. Kukaitis, but in order to increase the number of effective cases, we have to ensure the right to effective remedy. The guarantees of clients and the protection of confidentiality of information is equally important and has been discussed in previous conferences. We spoke about the powers of different institutions in terms of the advocate and client secret. This is a popular area where so many cases are being considered in the European Union. Thank you very much for your interesting presentation, and I would like to give the floor to our guest from the Gdansk University, Professor Emeritus Dr. Anna Rytelevich-Warszoka. She will speak about new tendencies in constitutional justice in the Republic of Poland. The Republic of Poland, its constitutional order, and the effective system of the division of powers is also concerning to us. We have been following the changes in Poland, and we wait impatiently for any resolution. And therefore, we will be very interested in hearing about the situation and the promises that Anna can give to us.
I did not understand this final comments. Yes, it's a great pleasure for me to be here. So thank you very much for the invitation. I had the possibility to speak here a few years ago. I think it was in 2017, and the situation in Poland has changed a lot. Not the direction we all probably would like to have. So it's a great pleasure to be here and to listen to so many inspiring presentations today. On Monday this week, I attended a big conference in the Senate of Polish Republic, the second chamber of the parliament. So we just celebrated the 25th year of entering into force our Polish constitution, but the atmosphere was not so similar as it is here. It was more depressing. We were just discussing the ways to defend the constitution that we regarded for a very long time as a very democratic and stable and safe and protective. And we also discussed the ability of the constitution to defend itself. So it will be somehow connected with my presentation today. The discussion on the model of constitutional review in Poland became a very topical issue after 2016, when the new political circumstances just resulted in the parallels of constitutional tribunal, and the doctrine and judiciary started to think how to overcome that problem and how to protect the constitution. On one hand, as it was mentioned today and explained, the Constitution as the supreme law, but also we must remember that Constitution is the guarantor of our fundamental rights. Yes, so that was extremely important to provide that it is observed by the authorities. Of course, we were thinking about solutions that do not violate the Constitution, but can be somehow based on constitutional provisions that we have. And Polish Constitution, when it comes to constitutional review model, is not very precise in several articles, so there's still some space for interpretation and for discussion. There's no doubt that the basic model of constitutional review is the centralized model based on Hans Kelsen's theories. And we have constitutional tribunal, like the Constitutional Court in Lithuania. It was introduced the Polish system in 1982, and then the Constitution of 1997 somehow regulated and it implemented some changes, very important ones, like the decisions of the Constitutional Court before the Constitution were not final, so the Parliament could just get rid of them. And now it's the final binding decision that results in loss of binding force by the law that is unconstitutional. But we do not have any provisions concerning common courts and Supreme Court. So what we are wondering now is, can common courts also decide on the constitutionality of laws that they are to be applied in a particular case? And the Constitution does not provide courts with such a right, but on the other hand, it also does not directly, expressly say that courts cannot do that. So the discussion is whether they can decide on the unconstitutionality of laws on their own, or maybe should they, in case of doubts, refer to the Constitutional Tribunal and just wait for the decision. So we are just thinking if there is a possibility to introduce a mixed model of constitutional review, Constitutional Tribunal and common courts. So the debate itself is not new, because it aroused great emotions and disputes already at the end of the 90s, when the Constitution entered into force. But at that time, the majority of the representatives of the doctrine of constitutional law stated that the competence of the Constitutional Tribunal should be exclusive. So the courts, in case of doubts, should just suspend the proceedings and just refer a legal question that is provided by the Constitution to the Constitutional Court. And the main argument presented then was that the competence norm must be clearly stated in the Constitution, so it cannot be presumed or interpreted from other norms. And there's no such norm, so it is impossible. On the other hand, supporters of the ability of courts to decide on the unconstitutionality of norms on their own pointed out that the decision of the court that the law is unconstitutional does not result in undermining the competences of the Constitutional Tribunal, but it just complements the decisions of the Constitutional Tribunal. It's not about giving courts the right to say that law is unconstitutional and should lose its binding force, but the results, like it is in the USA or in the Scandinavian countries, should be just incidental. The review by common courts should be ad casum and with inter partes effect, leading at most to the refusal to apply particular law in particular case, and the law would be still binding, would be still in force. The position of that the competence of the Constitutional Tribunal to conduct the constitutional review was that it is exclusive was also supported by the Constitutional Tribunal itself. So in the judgments of 1998 and 2000, the Constitutional Tribunal stated directly that this dispersed constitutional review is not justified in Poland either by the principle of direct application of the Constitution that is provided for in Article 8 of the Constitution, or by the principle that judges are bound by laws and by the Constitution when exercising their office. Because these two articles are important in that discussion. Supporters of giving that right to common courts says that each judge is bound by the Constitution and the law. So a Constitution is superior, and if there is a conflict, so the judge, if it is possible in particular case, should just apply directly the Constitution. On the other hand, the Supreme Court initially took a different view, presenting the concept of allowing a court to reject a provision that is clearly unconstitutional in particular case. So there was a dispute not only in doctrine but also between the highest authorities of judiciary. And then finally the Supreme Court approved the position of the Constitutional Tribunal, and in 2004 decided that in its judgment that a court hearing a case may not refuse to apply a provision of a statute on the grounds that it is unconstitutional. If it has serious doubts in this respect, it should refer the relevant legal question to the Constitutional Tribunal. So that was the end of the discussion. Such standpoint was repeated later on in several other judgments, and such was the practice also in the following years. So our courts did not used to decide on their own on the constitutionality of laws. However, everything changed after 2015 or 2016 more, and we came back to the dispute surrounding the Constitutional Court, as the Constitutional Court could not effectively fulfill its competences. So there was a discussion again about the possibility to do that by courts. And at the moment, most in the doctrine, professors of constitutional law, they in vast majority agree that the courts can do that, can decide on the constitutionality of law that is to be applied in a particular case, and apply directly the Constitution if they find the law unconstitutional. The discussion now is what is the scope of that right. So there are some professors who says that it was always possible, so this is just to be derived from the Constitution. We can derive such right from the Constitution. But the majority says that it is just something exceptional, that such right of the courts can be derived from the Constitution, but courts can use it only because there is the necessity, constitutional necessity. So it's claimed mainly that the dispersed constitutional review is an emergency constitutional review, which should be perceived as an expression of some kind of self-defense of the Constitution. And faced with the constitutional crisis that we have now, it's argued that a court can decide on the constitutionality of the law to be applied and refuse to apply that law under certain circumstances. So they are, the first one is that the provision of the law cannot be reconciled through the application of pro-constitutional interpretation with a particular constitutional norm or principle. Then the case has not yet been decided by the Constitutional Tribunal, just not to undermine the position of the Constitutional Tribunal. And the third one, that there are no conditions at that moment to obtain a decision of the Constitutional Tribunal. And when it comes to this last point, it's called the doctrine of necessity. It's based on this inability of the Constitutional Court to act at the moment, is based on the controversies related to several issues concerning the Constitutional Tribunal. So first of all, the adjudication by persons who in fact are not judges within the meaning of the Constitution, because in 2015 3 judges, so-called judges, were just elected for places that had already been taken, already occupied legally. And then controversies are because Some duly elected judges are not allowed to judge because the president just failed to organize the oath ceremony in 2015. This is the same, the first chamber of the parliament to elect judges, but in order to take the duties, they must give the oath in front of the president of the republic, so he just hasn't done that until now. Then violations of the constitution and the law in the election of the president, current president of the Constitutional Tribunal. So there are also many strong legal arguments to support the thesis that the person currently head in the Constitutional Tribunal, has been elected in with the violation of law. The appointment of one of the persons defectively elected as the judge of the Constitutional Tribunal to be in the position of vice president in 2017. Then there was a doubtful practice of exclusion of some judges properly elected before 2015 from adjudicating. So till 2019, judges Piotr Tuleja or Marek Zubik, who was also here, a guest here at that conference, they did not get any cases to consider. Then arbitrariness in determining the composition of constitutional tribunals, adjudicating panels. There is very frequent use of deviations from the alphabetical order provided by law. And there are changes, numerous changes of the judge reporter and changes of the already established panels. And last but not least, the controversies concern the actions of a number of judges of the Constitutional Tribunal elected after 2016 who seem to violate the principle of impartiality by their statements, by their engagement in public life and behavior in the public sphere. And also, in addition to that doctrinal changes, these views, there are also visible changes in the judiciary, in the case law that we have. There are a number of rulings already in which judges decided not to apply law, statutory law, because in their opinion it was unconstitutional. In 2016, the Supreme Court expressed also the opinion that the Constitutional Tribunal is responsible for deciding on the constitutionality of laws according to the Constitution, but only as long as it can perform its function properly. Yes, so this is also the judges that notice the problem. And when it comes to, just to provide some examples, to the judgments of common courts, in, for example, 2016, the Court of Appeal in Wrocław assessed the new wording of one of the articles of the Code of Criminal Procedure allowing the use of the fruits of the poisoned tree, so the evidence collected for the purpose of criminal proceedings as a result of unauthorized acts, and the court ruled that these provisions could not be applied as in particular case because it could not be understood in such a way that evidence collected as a result of provocation could be used in the proceedings. Then another example concerned, it was the Supreme Court's resolution of September 2020, which concerned the law that reduced pensions of people who served during the communism. They performed different duties in the different authorities of the state during the communist time. So the Supreme Court pointed out that the only formal criteria is not enough to reduce the pensions. So it pointed out that the analysis of service to a totalitarian state should take into account a particular case and it should be considered. It also pointed out that the flagship law of the ruling party was enacted in disregard to the basic principles of the rule of law led by mainly, first of all, collective responsibility. So consequently, there was a lot of judgments made by common courts, in which they changed or repealed the decisions of administrative authorities issued on the basis of that law, reducing these benefits. We are just in the middle of the discussion in Poland. The crisis concerning the Constitutional Tribunal has undoubtedly shed new light on the problem of constitutional review in Poland. In a more theoretical perspective, we can observe the reinterpretation of the Constitution. In Poland, our Constitution is very difficult to be amended, so the majority party cannot do that, and that is why all the changes that we have, in fact, are just or with the violation of the Constitution in ordinary laws, or just, we are trying to invent the new ways of interpretation. But just to sum up, there are some questions and problems that are to be solved. So the first one is that discussion that we have, if the Constitutional Tribunal does not perform the function of constitutional review and other solutions have to be looked for, can the burden of performing this function be entrusted to common courts? And if yes, it must be considered what conditions must be fulfilled to do that, and what dangers it may entail. Then we wonder, should the current debate on the dispersed constitutional review focus on searching for some response to the crisis only? So should we look for some exceptional, incidental, determined by this necessity solutions? Or should we look at the problem in a more wide perspective, a general perspective that could be applied also in future? So could the dispersed review just complement, just help to fulfill the constitutional review in future as well? In case of the second approach, in general, we must consider the role of judges who will rule on unconstitutionality, because this is a very important thing. We can in doctrine say, okay, it is possible, but this is the judge that must be brave enough to do that and must to bear the consequences of that, especially that we still have problems with the independence of judges. So this is the basis, just to provide them with the independence. We've got a big problems with, which has been noticed by the European Union, by other countries. So with this disciplinary chamber, yes, and disciplinary proceedings. So this is something that, if we decide for that, judges must be provided with important guarantees. And we discuss if the current legal instruments are sufficient to guarantee the rule of law, or should we make some additional constitutional safeguards? Can the constitutional review by common courts be derived from the Constitution, or maybe we should press on amending the Constitution and writing it into the text in future? And we also think about the statutory changes to be introduced. For example, there are ideas to create a constitutional chamber of the Supreme Court, because the biggest danger of that dispersed constitutional review is that it can be a danger for uniformity and consistency of the jurisprudence, because there are more than 10,000 judges in Poland, so maybe the creation of some such chamber could be profitable. Yes, so this is the discussion that we have at the moment, and thank you very much.
Thank you, dear Professor, for joining us and naturally for sharing your positions, views, thoughts about the situation related to the constitutional review in Poland. I would say in this very unusual situation in Poland. Thank you very much. Na, iš profesorės pranešimo tikrai labai įdomu, kai susidarius iš esmės dėl politinių tam tikrų priežasčių.
It is very interesting that due to certain political reason, the constitutional review becomes problematic. And when the diffused constitutional review was changed, and the professor has talked about how to address the situation, and diffused constitutional review may be considered as one of the ways out. So, her opinion that this decision should not be temporary. Thank you once again, Professor, and now I would like to give the floor to the last speaker of this conference and of this part. The floor goes to Dr. Madis Ernets, judge at the Tartu Court of Appeal, and his presentation is entitled Problems of the Estonian Constitutional Review Model. Dr. Madis Ernets will attend the conference virtually. When I looked at this presentation, I really liked some of the ideas, and Dr. Ernets will probably talk about it. He talks about the constitutional review model of Estonia as unique and specific. Estonia, differently from other countries, including Latvia and Lithuania, has no specific authority for constitutional review, such as, for example, Constitutional Court. Therefore, this model of constitutional review is very interesting and at the same time quite complicated. Now the floor goes to Dr. Madis Ernets.
Ladies and gentlemen, I am honored to have been invited to this excellent conference and delighted to be in Vilnius. Unfortunately, only virtually today. Happy ongoing year of the Constitution to our dear, almost neighbor. The Estonian rights protection model has been described with good reasons as unique, as exceptional, as peculiar, or as entirely unknown and untested institutional configuration. Why is that? Because it intends to combine the prevailing concentrated or Austro-Kelsenian or European model of constitutional review with some elements of the US-American type of diffuse judicial review. Today, I want to explore where this combination comes from and what are the main issues related to this institutional background of our rights protection architecture. Where does it come from? The roots of Estonian version of the judicial review go back to the first independence period, from 1918 to 1940. More precisely, according to recent discoveries, the judicial review in Estonia can be dated back to May 11th of 1926. The case in question concerned a decision of the Minister of the Interior on the basis of the law on the election of the county councils, by which the minister annulled the electoral list of certain voters' association in the county council elections of 1923, and consequently terminated the mandates of the county council members obtained by the candidates of that list. Karel Baars was an attorney, member of the particular voters' association and members of one of county councils. He, together with several other members of county councils who had faced similar fate, challenged this decision in court. One of their central arguments was that the change made in the composition of the county councils was unconstitutional. The case reached the Riigikohus, who declared inter alia. The Estonian courts must act in accordance with Article 86 of the Constitution, and according to this, every court in which the question is raised that a certain law does not comply with the Constitution is entitled and obliged to give an answer to this question. In deciding the question whether or not an ordinary law is in accordance with the Constitution, the court must act in the same manner as in deciding whether or not a mandatory statute is in accordance with the law. If the court finds that the mandatory injunction is contrary to the act, it must disapply it, and the court must also disapply the act if the court finds that the act is contrary to the Constitution. To make it clear, it was not constitutional review, but judicial review according to the US-American model. According to the current state of research, the judgment can be considered as the beginning of the diffuse theory-based judicial review in our jurisprudence. But where did it come from in 1926? It should be recalled that just 6 months earlier, November 4th, 1925, the German Reichsgericht had proclaimed the following in its famous judgment. Since the Reichsverfassung itself contains no provision under which the decision on the constitutionality of Reich laws would be withdrawn from the courts and entrusted to a specific other body, the right and duty of the judge to examine the constitutionality of Reich laws must be recognized. Could it be that this temporal proximity is no coincidence? In my opinion, it is more probable that it is not a coincidence. It is very likely that the judges of the Riigikohus at that time were well informed about what was going on in Europe on the field of constitutional adjudication. Thus, it is probable that the inspiration for this solution reached Estonia from Germany, and that this solution was not imported directly from the USA. But where do the concentrated elements of the constitutional review come from? Our present court system is pre-constitutional law. The new Courts Act was prepared from the end of 1980s and passed by the Supreme Council October 23, 1991. That is after formal restoration of independence, but before the adoption of the new constitution. The model of the court system that was introduced in 1991 was based on the pre-war model, influenced strongly by the Courts Code of 1938. At the Constitutional Assembly, neither the court system nor the constitutional review model were profoundly debated. However, Klaus Bechtold, the Austrian expert, invited to our Constitutional Assembly, commented October 29, 1991, the draft constitution and pointed out some issues connected to the planned system of judicial review. And if I'm correct, all these courts have the competence to decide whether there has been an infringement of human rights or not, if that is correct. This is a point that should be probably discussed. If this is correct, you may face difficulties if there are a great number of courts which may decide on human rights. It might be asked whether the Supreme Court be in a position to guarantee, so to say, certain unity of jurisprudence. This is the point which should be reconsidered, and I have not found clear indication in your draft whether the courts could be competent in human rights cases which arise out of activities of administrative authorities. Again, this is just a guess, but it might be the explanation. This is the probable explanation why we do have in our Constitution of 1992 the articles like 149, paragraph 3, second sentence, and 152, paragraph 2, which both, in my opinion, are clear expressions of a centralized constitutional review model. What are the consequences? There is no historical or logical connection between the two origins identified. Nevertheless, these contrasting origins continue to exist as theoretical background in current main debates of our rights protection architecture. The most important type of proceedings of the present review architecture is the concrete norm control, which may be initiated by any court that concludes that a law on whose validity its decision depends on is unconstitutional. At the first glance, this procedure seems to be similar to Austrian, Belgian, French, German, Greek, Italian, and Spanish concrete norm control proceedings. In all these jurisdictions, judges have the right to ask the Constitutional Court for an opinion to the constitutionality of the relevant law before a final decision in the case is made, if they deem it necessary. Thus, the review model is incidental and proactive. In Estonia, however, according to the prevailing interpretation of the Constitution, and similarly to, for instance, Portugal, the constitutional review proceedings start when a court has made the decision in the case. That means, as a rule, has delivered the judgment or, in procedural matters, the ruling. It is thus ex post facto and reactive. Thus, the main difference to the Estonian concrete norm control system is that in Estonia the start of constitutional review proceedings depends, according to the prevailing opinion, on the prior final decision in the case. The most important question related to the concrete norm control proceedings concern the debate whether the Riigikohus interpretation of the Constitution that a lower level court shall deliver the final decision in the case prior to the constitutional review that has been made since the early days of constitutional review is correct. As a supporting argument, the shorter duration of the proceedings has been put forward. Nevertheless, the present understanding of the initiation of the concrete norm control has been criticized in the literature. The main argument of the critics of the prevailing view is the possibility that when the Riigikohus does not follow the opinion of the lower level court on the unconstitutionality of the law left unapplied, the judgment of the lower level court may stand despite its unconstitutionality. That could result in an unconstitutional decision remaining in the legal system. Without being able to dig any deeper in this place, it can be established that this is the prime example of the clash of different understandings of the diffuse and concentrated theories. Second, in the present system of the constitutional review, individual constitutional complaints against the judgment of the last instance court are excluded. This constitutes a serious gap in the system of constitutional rights protection that cannot be compensated with other procedural safeguards. This controversy is directly influenced by the basic dispute of diffuse and concentrated theory, because the supporters of the diffuse theory do not recognize any gap in the rights protection system at all. As the third example, neither the Constitutional Review Court Procedure Act nor any other legal norm provides explicitly for an individual constitutional complaint to the Riigikohus. The individual constitutional complaint was not discussed in the travaux préparatoires of the Constitution. However, the discussion about the necessity of the individual constitutional complaint started soon after the entering into force of the Constitution. Since the legislator has remained passive, the Riigikohus took the initiative and created the individual constitutional complaint by means of case law. Hitherto, there has been at least one successful precedent, the famous Brusilov case, and the Riigikohus has in several decisions stressed the possibility of an individual constitutional complaint deriving directly from Article 15, paragraph 1 of the Constitution. Even the Constitutional Review Court Procedure Act from 2002 can be interpreted in conformity with the Constitution in the way that the individual constitutional complaint exists already. However, the Riigikohus and some of the justices have continued to send controversial signals, and the Riigikohus has even denied the existence of the individual constitutional complaint after the Brusilov judgment. The theoretical background of the Brusilov critique is based on the understanding of the Estonian constitutional review system as a diffuse system, meaning that every court of law should be entitled to perform constitutional review. Obviously, however, without the constitutional complaint, no complete protection of fundamental rights can be guaranteed. What we have seen is that the roots of this controversy stem from different stages of constitutional history, and the connection is rather accidental. All the structural issues outlined and some other cannot be solved reasonably without bringing any clarity into this basic dispute. As a final remark, I would like to return once again to the mid-20s of the last century, as Riigikohus introduced the diffuse theory into the Estonian legal system. At that time, the theoretical debate on the foundations of the constitutional adjudication in our model country Germany was far from over. On the contrary, the debate of the time is described in retrospect as the methodological and directional dispute of Weimar constitutional law doctrine, der Methoden- und Richtungsstreit der Weimarer Staatsrechtslehre. It is well known that the partial debate on the foundations of constitutional adjudication was decided in its essential points in Hans Kelsen's sense only after the Second World War. After restoration of independence, our Latvian and Lithuanian neighbors also decided this debate in its essential points in Hans Kelsen's sense. Paradoxically, in Estonia, the 1926 Riigikohus decision still casts its long shadow on today's case law and doctrine. In short, there is nothing else to do but to state that our methodological and directional dispute of constitutional law doctrine has not yet been decided, and there is still much to learn from the Weimar debate. Happy 30th anniversary of the Constitution to all participants, and thank you very much.
Thank you for Dr. Madis Ernits. This was the last presenter of today's conference. According to the program, we should have a discussion. But according to the fact that we have run out of time, and we have heard many ideas and thoughts from our presenters, we decided not to have the discussion part. But we want to address you and ask the audience whether you have any remarks. And first of all, I would like to ask Professor Toma Birmontenė, maybe you have any remarks that could be made on today's presentations. Professor, you can join us.
Tikrai nėra už ką. Ačiū Jums.
Taip, bet visų pirma norėčiau
Thank you. First of all, I would like to conclude our conference and to thank. I have no doubt that many participants of our conference are following us online. I also give special thanks to those who were able to join us physically, because without the live conference, without the live audience, the conference would be much more serious and sad, and it would resemble a remote lecture. So I would like to offer a round of applause for our audience. I'm also happy that we had so many distinguished guests, scientists, politicians, and lawyers. Vytenis Andriukaitis could be called a lawyer because he bombarded the Constitutional Court and contributed to the drafting of the Constitution. The title of the conference means the path that we are going throughout 30 years. 30 years is a short span of time, and it is difficult to make any precise conclusions because there's still a long way ahead of us. Today's conference shows that we have to preserve and defend the Constitution, the principle of the division of powers, to defend the Constitutional Court that interprets the Constitution. But we see that other countries also face certain problems. The presentation by Dr. Anna Rytel from Poland in 1993, our Constitutional Court made its first steps in the direction, and now we can see that the political processes can affect the system in a very negative way. The Constitution should not be only celebrated, but also defended and protected, and be happy that it is difficult to amend the Constitution. We have to look for ways in cases when politicians might influence a political crisis and initiate the change of the constitutional model. The mixed system of constitutional control is a very complicated issue. It poses many threats. Colleague Anna says that 10,000 judges in the Constitutional Court have to be brave enough to take necessary decisions that might signal the end of their career. We also saw the examples of other countries as well. First of all, Ukraine, which sees its constitution in the face of today's war situation as a document that the nation wants to change and amend.
Profesorius pristatydamas Konstitucijai iškilusius iššūkius.
When the challenges to the Constitution were named by the professor, he proved that war and Constitution are incompatible, that the Constitution can defend and safeguard the state, but the Constitution cannot defend us from our external enemy. Therefore, inside the country, political processes and wars shows certain difficulties and certain shortcomings in the Constitution. Professor who described the situation said that the new Constitution in Ukraine needs to be adopted. The situation in Latvia is different. The Constitution in Latvia is effective since 1922, with the effective amendments, including the preamble in 2014. We are happy that the President of the Latvian Republic, of Latvia, also recalled that Lithuanian experts and lawyers also participated in the process of conflict resolution. And the conflict was whether a constitution can be amended or a preamble added, when the Constitution of 1922 had no such preamble. The discussion was underway in Latvia. It was a very difficult doctrine situation when the Constitution of 1922 had to be changed in the way that new preamble was added. The Constitution is a live body, a live document that has to be in line with the problems of the 21st century.
Aišku, galime sakyti, galbūt per konstitucinę jurisprudenciją, per konstitucinę doktriną galėjo atsiskleisti.
Constitutional doctrine or jurisprudence could give rise to different elements, but Latvian politicians finally decided that a modern preamble should be added to the Constitution. The Lithuanian Constitution can be celebrated, but it also faces certain challenges: the independence of the judiciary. The Constitution of 1791 clearly stated that courts are the only institutions responsible for justice. Effective judicial remedy should be ensured for people. This was also a territorial principle, but the implementation of such principles and introduction of such principles, I agree with Judge Ždanaitė that it was considered a kind of idea, but having such an idea in the 18th century was very brave. And these ideas continue to be implemented nowadays as well. So in our constitutional traditions, those ideas seem to be perpetual, though we don't want them to be so. I would like to say that the Constitution adopted in 1992 was born in the period when Lithuania was not a member of the EU. But the courts find the possibility to find the way between the national court and the national law and the EU law. I also like to thank the presenters of the first part of the conference who spoke about the doctrinal issues. And also express my compliments to the chairman of the Council of the Lithuanian Bar Association. Today, you appreciated that some of the grievances that you expressed in the previous conference have been finally achieved. The changes were implemented. And let us hope that other types of criticism have been heard by politicians and decision makers. I would like to thank all the participants and all the speakers, the presidents. It was a unique situation when the president of the Republic of Latvia and the Republic of Lithuania took part in today's conference. And we're very happy to hear the presentations of politicians or people that were the founding fathers of the Constitution, who saw and evidenced the drafting on the Constitution, and they could describe the processes of drafting the Constitution. I also have to mention the Constitutional Court, the President of the Constitutional Court and former President of the Constitutional Court, that have a completely different view and approach on interpreting the Constitution. Despite some compromise that was achieved and despite some pending issues, it seems that the Constitutional Court is effective in its mission, and let us hope that this will continue in the future. Thank you very much. Thank you, Professor. You spoke about, you made thanks. I would like to thank, first of all, the organizers of the conference, Mykolas Romeris University, the Seimas of the Republic of Lithuania, the Constitutional Court of the Republic of Lithuania, and the Lithuanian Bar. My colleague Jolita also wants to say some thanks.
Kas kam dėkos, tai prašom, Jolita.
So, Jolita, the floor is yours. We also have many people who contributed to the organization, influent organization of this conference. We have mastered different technologies that can help us. I would like to thank the IT specialist, Eligius Abaris, who was responsible for all the technical issues. I also would like to thank the interpreters for helping to translate the thoughts. And finally, a special thanks goes to Aidena Bacevičienė from the Committee on Legal Affairs of the Seimas.
Man atrodo, čia vieta paploti.
So, let us give a round of applause.
Ir tuo, kad mūsų konferencija baigėsi, praktiškai jau visai baigėsi, nereiškia.
And we are approaching the end of the conference, but our celebrations are not over. After this conference, we would like to invite you to join other events in commemoration of the anniversary of the conference. It will be the celebrations will be organized in Vilnius University, where modern challenges to the Constitutional Court will be discussed on Monday. On Tuesday, the Constitutional Court will be organizing another conference. This conference will be accessible online. On Wednesday, the President of the German Federal Constitutional Court will make a lecture in Mykolas Romeris University. Professor Stefan Garbert will speak on the state of the Constitution. I invite you to these events because this is a great opportunity. We are happy to receive guests from Germany, and we are happy that many more people can enjoy the lectures of our foreign guests.
Ar jau baigėsi laikas, taip. Tai aš tada dar norėčiau padėkoti kaip kartu su Jolita, kaip moderatorius šios sesijos. Kartu su Jolita mes dėkojame pirmiausiai šios sesijos pranešėjams, tiek čia dalyvavusiems, tiek kolegai iš Tartu prisijungusiam nuotoliniu būdu. Buvo labai malonu moderuoti šią sesiją ir dalyvauti konferencijoje. Dar kartą sveikiname Konstitucijos 30-mečio.
We would like to thank all and we would like to congratulate you on the 30th anniversary of the conference. Long live Lithuania.
Ačiū moderatoriams.